What's up, everybody? On today's video, we are going to break down more cop testimony. Can we believe it? Can we not? What did the Commonwealth get out of Mr. Officer Tully? And what about the DNA evidence? What does it prove? What does it not prove? And right off the bat, I'm going to respond to some of the Twitterverse and what's going on in this case and the craziness and the wild accusations being thrown around because it was a funny day for me to look back on Twitter/X. So let's get into it. Make sure you guys hit the like button and subscribe to our channel if you have not done so already. So one of the wildest parts of this case and this journey has been people accusing people of thinking or doing things because of whatever side or whatever it is they're saying or whatever it is they think is happening in this case. And to make it as clear as possible, what we do here is I don't care when we go into a case who's going to win. As we watch and listen to a case, I will tell you where I fall and what side I think justice falls on, which is the point of the criminal and civil justice system. And I think it's hilarious when people tag certain accounts or tag people in comments and they say, this person wants clicks, so that's why they're on this side. Or this person's an idiot. He's trying to play to his audience. That's why he won't just say what he knows to be true. Never have I ever been accused of not saying what I think is true in my life, in my real life. Of course, on YouTube and Twitter, maybe that happens. But the vast majority of what we do when we break down evidence and testimony on this channel is we look at evidence, we look at testimony, we try to figure out how each side, how each lawyer is going to use this evidence and use this testimony. And by doing that, we look at what the jury is going to take from this evidence or testimony. So if I'm wrong, which I've absolutely been wrong before, if you're here and you think I'm going to get the verdict right on every case, this ain't the right place because I've been wrong before. But what I try to do is I try to think, because the standards in most trials and most jurisdictions are, what could a reasonable juror find? And so when we look at the evidence today, we're going to do the same thing. I'm going to say, this is how I see it. This is how I think the lawyers want to use it. But if the jury comes down on the other side, I think it's reasonable. I think it's possible. And people hate to hear that. They think there's only one way to look at anything and everything. And that's just not true. Usually there's a different way than you look at a piece of evidence or testimony that another reasonable person that you can disagree with. That's why I like disagreeing. I like when we talk through this and we see that reasonable people can disagree. They can do it respectfully, and it can and will happen on a jury. So we're going to talk about some evidence, especially when we get to the DNA evidence. And there is going to be multiple ways to look at this evidence. There are very clear different ways that two sets of lawyers look at this evidence. And we have to realize that that is in the realm of possibility and reality that could happen at the end of this case. Now, we'll talk about how we see it. We'll talk about where we are, of course. And we're going to go through this evidence and this testimony, break down what we think was good for each side, bad for each side, and indifferent. There were some red herrings today, I thought. There were some things that were nothing burgers that some people want to make a big deal. And I think that's fine because maybe there's a juror. Anytime enough people in this chat, which I respect, and for the most part is very respectful, if a bunch of people in this chat think something, even if it's the minority, that gives me a good indication it's possible that at least one juror may feel that way. All right, it's enough. Off the soapbox now. Let's get into it. Okay, let's get into the testimony today from Big Dog Tully, one of the bosses over there. And we're going to get into what he did and why he did it for the most part. And that's going to be most of what we dig into today.
House. And so I don't believe that Mr. O'Keefe entered the home. So I had no nexus to the house.
And what, if any, evidence did you have that Mr. O'Keefe had ever entered the home, 34 Fairview Road, on January 29th or on any other day?
I don't. On the contrary, I have evidence that he was outside, but I don't have anything putting him inside the residence.
So what's really interesting about that, right off the jump, is I was like, oh, good. We're going to get John O'Keefe's cell phone data in through Tully to show that John O'Keefe never entered the house. When he said that, that's what I meant. And then I was like, oh, silly rabbit. He's talking about the testimony from the McCabe's and the Alberts, which we've already heard. because unless I missed it, I don't think he brought up any of John O'Keefe's cell phone data that proved he was just outside. But instead, the witness testimony, who has said that they saw John O'Keefe out front besides obviously when he was laying there? Now, we've had evidence and testimony that he never entered the house. So if that's what he means, okay. And they saw the car outside the house, and somebody did say they saw a male in the car. So I get all that. But that's a nice way to tie a little bow around all that circumstantial evidence, which, guess what, can be enough to convict somebody.
Now, you're aware that, or you testified yesterday that at some point while you and CERT team were conducting search at 34 Fairview, the Sergeant Mechanic and Trooper Proctor were following a tow truck with a defendant's vehicle from Dighton to the Canton Police Department, correct?
Yes.
And in reference to taking the vehicle to the Canton Police Department, how was that decision arrived at? What, if any, discussion, or what, if any, other options you had?
So Sergeant Mechanic and I had conversations. It was ultimately my decision of where the vehicle was going to go. And so we need to find a location that was secure, indoors, and perfectly heated. And so we start going through a checklist of what's available. So you start thinking, obviously, of state police facilities. So between Dighton and Canton, where our
I'm going to slow it down a little bit. We don't have quite as much to get through, so we can slow it down just a bit, just a tad.
offices as well. You have the Foxborough Barracks, which was, I worked out of the Foxborough Barracks. The garage was probably not appropriate for that large vehicle to get in there. It's an old building. I worked at the State Police Barracks in Milton. That's even worse, with a smaller garage that's attached inside of an older building. So the Canton Police Department was the next step. It was kind of checked all those boxes. It was inside, it was secure, and it was heated.
Now, whether we agree with that or not, at least he has given us a reason why they parked it at Canton. The size, the location, it was heated, it was big enough to fit her car. Fine. Okay, fine. At least they gave us that.
Now, over the course of your career, specifically within the homicide units of the second unit of the District Attorney's Office, approximately how many investigations have you led or been a part of in relation to? Let me first ask you this: as far as your unit is concerned, how is it that, from a staffing perspective, how is it that an investigation is conducted as far as certain roles, or can you speak a little bit about sort of the roles that different people within your unit play with reference to an investigation, just in the general sense?
Within the unit, we have different sections. We have the homicide section, narcotic section, and special investigations. So each is kind of broken up into that. Obviously, the homicide section will undertake homicide investigations, but we work as a team. So there'll be situations where you may need an all hands on deck just to get some people out there. So the narcotics folks will help with homicide investigations, and vice versa. The homicide people will help with narcotics investigations when needed.
Your Honor, may I just have a moment?
Yes.
We're going to get into here in a minute the conflicts in this investigation.
Collection point for the investigation. So they are the person that would gather the evidence, the records, hold those records, and then somebody needs to be held accountable for a to-do list or something to do. Supervisor would go to that one person, as well as the district attorney's office would know who to contact about a certain case, and then we'll go from there. Obviously, that case officer usually is a rank of trooper, especially when talking about unattended deaths. They have a sergeant and 2 lieutenants that are supervising them in that realm.
And as far as interviews are concerned, what, if any, sort of policy is there with regard to troopers, and how many would be involved in the interview of any witness?
We would always have 2 people present, either a trooper and a local detective, or 2 troopers. Just one ask questions, one take note taking. It's just good practice.
And with respect to this investigation, the locals, as far as Canton Police Department, was not something that you utilized, correct?
Correct.
And again, I know you testified a little bit about it yesterday, but if you could just reiterate or expound upon sort of what your discussions were with the chief as far as Canton Police Department's involvement in this investigation going forward, following the early morning hours of January 29th.
Our conversation circled around in the early hours about the homeowner of 34 Fairview, which was Brian Albert, has a brother, Kevin Albert, who was a detective with the Canton Police Department. And so where we were, we had essentially zero information about the investigation. We wanted to remove any appearance of conflict by not having Kevin Albert or any of his coworkers involved in the investigation.
Was that in the investigation in its entirety, or the interviewing process, or how was that sort of delineated, if at all?
Definitely no interviews. They were not involved in any discussion. Essentially the entire investigation.
Oh, really? Did you catch that? Because usually when I don't pipe in too often, some people can fall asleep. So let me back that up again. He gives us the reason they're conflicted out, and then Lally tries to serve it up on a platter and say, well, do you just mean for like the interviews, right? That's like what people are really conflicted off for. And he's like, Nope. I mean, no, they should not be involved in discussions. Pretty much conflicted off the whole thing.
Circled around in the early hours about the homeowner of 34 Fairview, which was Brian Albert, has a brother, Kevin Albert, who was a detective with the Canton Police Department.
So obviously there's a conflict there because of that. He explains that. And now what does the conflict look like practically?
And so where we were, we had essentially zero information about the investigation. We wanted to remove any appearance of conflict by not having Kevin Albert or any of his coworkers involved in the investigation.
Any of his coworkers would be anybody else in that police department.
Was that in the investigation in its entirety or the interviewing process, or how was that sort of delineated, if at all?
Definitely no interviews. They were not involved in any discussion, essentially the entire investigation.
They were not involved in any discussion, essentially the entire investigation. What about the text messages with Kevin Albert about who you're interviewing and where they're interviewing them and helping set up the interviews? Not just with the police department, but specifically Kevin Albert, the person that creates this conflict. That's problematic. Proctor didn't get the memo. People are saying it's like, yeah, beach nut. It's kind of a big deal, right? Because Proctor is in fact the lead officer on the case. This was one of the biggest points for me today is like the boss man, Tully, who gave Proctor a talking to supposedly. This is how he looks at the conflict. And that's not how it happened. It's not how it happened. Lisa said, do you think it's possible there are paid people in these chats? Well, I know how one thing is impossible. They are not paid by me. I am not paying anybody in this chat to say anything. If I did, it would be boring. By the way, look at the chat. You can tell I'm not paying them to say some of the stuff that comes in the chat, right? Azam said, reading those make me angry. I can't imagine how you feel, but you're better than me. I think they didn't watch you cover other cases. They just clicked the hashtag. Yeah, I don't know what people's motivation are. What do they think? Do they think they're really going to get me? Do they think they're going to silence me? Do they think they're going to make me be like, okay, now I'm going to look at the case this way because you called me out on Twitter? Like, I literally don't care. I watch these cases. I listen to these cases and literally just try to explain them from a lawyer's perspective. That's it. And I think that's what people find interesting. I don't think you'd find it interesting if I came in here and I'd be like, well, this person's guilty, on to the next case. Well, this person's not guilty, on to the next case.
And as far as the case officer is concerned, is the case officer someone who, particularly in a homicide investigation, is as far as a decision regarding charging, is that something that the case officer would be tasked with?
No.
Now, turning our attention back to your testimony yesterday, there were items that you had retrieved from search on January 29th, correct?
Yes.
And as a precursor, if I could ask you sort of, over the course of your career, specifically within the homicide unit with the district attorney's office, about how many death investigations, homicide investigations have you been involved?
I would say in excess of 600 unintended death investigations that I personally investigated. That's not counting those phone calls the calls I end up declining that I'd mentioned yesterday. In addition to that, I probably have either worked or supervised 75 homicides. And then getting back to the unintended deaths, I've supervised countless since I've attained the rank of trooper and lieutenant. Sergeant and lieutenant. And
with respect to your training and with respect to your experience, how many of those investigations have involved injuries which included a break?
I or L. This is I, L. I can't tell what this is. 100% feel you on this, and we're going to talk about it. We're going to show some examples and talk about why it was annoying to me today.
Probably 10 to 20% of them.
And if you could, at least from your understanding, if you could explain to the jury what your understanding of what is an abrasion.
Objection. Assistant.
So once again, Lowley's trying to lay all this foundation so this cop can pretend to be a doctor on the stand. And at some point, if somebody's going to ask you questions and you think you know, fine. And the judge will let you, Lowley should know better. Lowley should know better. And I lost kind of my patience and the gracious way I've been trying to explain the way he's handled the case, because it's not a good prosecution job. And there are some things he did today that he has to know are not the right way to do it. And this is one. Continuing to try to get medical evidence out of cops, you should know better. And lawyers are not supposed to do stuff they know is the wrong way to do it. It's almost like golf, where we call penalties on ourselves. And I know people can laugh, and both sides have done it, and been line steppers, and I get that. But he should know better than to try to get this testimony out of him so far. And he's not done, because they try to force the ultimate issue here.
With regard to the items that you recovered on January 29th, There was one piece of clear plastic you testified yesterday had something that you termed as stippling on the outside, correct?
Yeah, I may have used the word dimples, but yeah.
Now, with respect to Mr. O'Keefe, at some point, did you have occasion to view photos of Mr. O'Keefe from the Good Samaritan Hospital?
Yes.
And with regard to the items that you recovered, what, if any, significance did you observe between those items and the injuries that you observed to Mr. O'Keefe?
The injuries to Mr. O'Keefe, I noticed the abrasions had a certain pattern on them. And I know that when a blunt force object is involved in causing an abrasion, the characteristics of the object that comes in contact with a person will often leave the characteristics on that person in the form of an abrasion.
And with respect to this specific case, as far as any
That right there should have been objected to. He shouldn't have even been able to testify to that.
items recovered on January 29th and your observations of Mr. O'Keefe, what, if anything, did you observe of any significance in relation to that?
I'd be comfortable in saying that the marks on Mr. O'Keefe are consistent with.
Objection. Sustained.
The jury knew where that was going. Once again, he was trying to get him to say the marks on his arm are consistent with the tail light. Okay. It could really backfire if the jury just looks at the scratches and is like, those aren't abrasions, AKA bruises, usually is what people think of abrasions, I think, for the most part. They're more like furrowing and scratches or scrapes or what a lot of the medical personnel has defined them as. So if you just lose the jury, try to trick them with certain definitions, but it was very clear they were trying to get him to be able to testify to this medical testimony. Lally, you've got to call an accident reconstructionist. You've got to call a doctor, a medical examiner to talk about the injuries. You can't get it in through your cops. And the fact that you're trying to get into through your cops, I haven't been trying to bang the drum for the big cover up and stuff, but if you're trying to get testimony that they're not experts in out of the people that everybody are pointing at to doing the cover up and pointing at them to say they're doing whatever it takes to make sure they get the girl with serious charges and to make sure she's effed, this feeds into that. You're playing right into the defense's hand by trying to push the envelope here because you know you're not getting it in. Yobi, you almost deserve to get paid with your with the jokes, keeping it light in here. Okay. Going to jump ahead a little bit to when they talk about the phone calls on Karen Reed's phone, which I found to be pretty interesting.
Mr. O'Keefe, and a statement that she had left the house shortly after 5 a.m. We then know that she arrived at the McCabe residence on Country Lane after 5:30. So we're trying to account for the movement of the vehicle for that 30-minute block.
Now, in reference,
there's testimony here in that 30-minute block. They try to make it seem like she drove back to Fairview. So that's going to be one of the big points we're going to look at in the details here. But that's what they're trying to do, just to give you kind of the overarching theme of what's happening in this part of the testimony.
2 phone calls, you've had occasion to review information related to the defendant's home.
Yes.
Now, you mentioned that about 4:45 in the morning, she made phone calls trying to ascertain, or allegedly trying to ascertain the whereabouts of Mr. O'Keefe. Is that correct?
Yes.
Prior to those 4:45 a.m. phone calls, were there other phone calls that the defendant placed?
Yes.
And to whom did she place those calls and about what time?
Starting at 12:33 a.m. to 6:03 a.m., there were 53 phone calls from Ms. Reed to a phone number associated with John O'Keefe.
And in addition to those phone calls to Mr. O'Keefe's phone, what, if any, other calls did the defendant make prior to those 4:45 a.m.?
There were phone calls to her family members, to Jennifer McCabe, Kerry Roberts, Camaranos. Those are the ones that are off the top of my head. I have the notes in front of me if I want me to refer to them.
You all right for the witness bank?
Yes.
Look through. She also called John O'Keefe's family. I'm going to jump ahead a little bit here to some of the maps you can see where they put on here 34 Fairview, the Temple, they put the Waterfall Bar and Grill, they put Meadows Ave, and they kind of showed where she was driving around all of this. And much of it's not disputed, right? Waterfall to Fairview to home to McCabe, I think McCabe's house in the morning. So a lot of the testimony was not disputed, and they have her on the library video. And of course, people are saying you can see on the library video that her taillight is not busted. And I get it. And to me, I don't trust my own eyes in looking at the video through the stream to say whether I can tell it is busted, it's not busted, how busted it is. So I'm not going to do that. A lot of you guys may feel more confident in that. The jury may feel more confident in that. they may become more confident in that as they are able to actually view it back in jury deliberations. I'm not. I thought that these maps were not effective. I do not feel like it was very clear and just clean cut exactly where she went. I've seen it done much better. I think the YNW Melly case was one where they made it visually pleasing to the jury in a way that I think that that helped move the ball forward for the prosecution. And then this is him explaining kind of the timing a little bit of why they think she might have at 5 o'clock in the morning. Basically, the allegation or the inference here from the Commonwealth is at 5 o'clock in the morning, she didn't just drive from John O'Keefe's house to get with the girls and get in the car and go looking, but instead she drove to Fairview. She saw John O'Keefe there, then went to the girl's house, played it off like she didn't know where he was, but yelled they needed to go back there, ended up there, and that's kind of how she knew right where John O'Keefe was. That can play both ways. That can be like, she clearly didn't know that she hit him or think that she hit him. It wasn't like an intentional crime that she was going back to check on, but maybe she did go look for him, found him, then went with them to try to cover up that she knew where he was. Okay. But does that prove second-degree murder? I don't know. And this is like a real reach to prove that she went back to Fairview before going to meet up with the girls, because they have no clue except for this, timing discrepancy.
You can take that. Mr. Officer, we can have the lights back up. Now, excuse me, Your Honor, if I could just have a moment.
Sure.
Through the course of your investigation, are you familiar with what time it was that the defendant, approximately what time it was that the defendant arrived at Ms. McCabe's home?
5:35, approximately.
And Ms. McCabe's home is located on Country Lane, is that correct?
Yes.
Now, from the directionality of that vehicle in the 5:18 a.m. Video, as far as timing is concerned, 5:18 to about 5:35 or so, is that consistent with the time it would take to drive from that area of the Temple Beth Abraham to Ms. McCabe's residence on Country Lane?
No, not if you were to drive directly there.
And so to that point, as far as what about
17 minutes, it sounds like, is this discrepancy, okay? So 17 minutes, they want you to believe that she drove from John O'Keefe's house to Fairview, let's just say it's a couple minutes, got out of the car, saw her dead boyfriend laying in the grass, didn't move anything around or do anything, then went to drive to get the girls, then came back over there. Or sorry, then got up, was perfectly fine, got back in her car, drove to see the girls, and was hysterical again. I mean, not to say she's perfectly fine. Of course, she's hysterical the whole night. I get it. That's a pretty quick turnaround to not be in shock if you saw something you didn't know was already there. And if she already knew that he was there and she left him there in the yard and hit him with her car, she wouldn't be surprised to find him there. Why would she need to go back and check on him if he knew he was there? I'm not tracking with it. I'm not tracking with it.
how that time doesn't match up? Is it short, too long, or something else?
It would take you much quicker to get there. It's about 1.5 miles from Temple Beth Abraham to Country Lane. You would continue north on Washington Street and just take a left into the Country Lane neighborhood. So the time to travel, 1.5 miles.
And from sort of the distance between either that Temple video and either 34 Fairview Road or Country Lane, were you able to find, locate, or retrieve any surveillance video in those areas that would capture the vehicle?
No.
Now,
So they didn't have any video to prove it, but that's just kind of what they think happened.
as far as you had mentioned earlier in your testimony, when we were talking about the earlier 12:17 a.m. Portion from the Temple Beth Abraham video, the directionality of that black SUV, both in 12:17 and 5:18, where is Fairview Road in relation to the directionality of the SUV that you observed?
That SUV could take a left onto Dedham Street and then a left onto Cedar Crest to enter down to Fairview Road.
And from your knowledge of the area, as far as travel is concerned, would from 5:18 to about 5:35 or so, would that allow for sufficient time to go from where it's viewable on the Temple Beth Abraham video for the vehicle to then travel to 34 Fairview Road and then travel to 12 Country Lane?
Yes.
All right. Then I thought it was really interesting. He explains how important the cell phone data can be to a criminal investigation. And I thought, wow, One side has been saying that this entire case, but it happens to be the defense. And that's why they're saying, why didn't you get these other suspects' cell phones? Why didn't you get any of the Alberts and the McCabe's cell phones? I know they got some of them. Why didn't you get Higgins' cell phone immediately? Not after the fact where they could have deleted stuff, where we know they deleted stuff. Because look at how important this stuff can be, including what they got from Allie McCabe's, right? He created that map based on the call detail records. And again, they showed the map. Salt Life Girl said, did this help the Commonwealth or the defense? A little confused today. Well, if you were confused, that usually helps the defense. If you're not tracking what the Commonwealth is trying to prove, and I agree with you, I felt a little bit of that today as well, that's good for the defense. So now we're going to jump ahead to cross and hear how Jackson takes his shot at Tully.
I'm not going to go in any particular order, so forgive me if I bounce around just a little bit. You indicated that on direct examination this morning that you didn't seek a search warrant for 34 Fairview, the interior of 34 Fairview, correct?
Yes.
To your knowledge, nobody under your supervision sought such a search warrant either, correct?
Correct.
You explained that in your mind, there was no probable cause to seek the search warrant for the interior of the home. Is that right?
Yes.
But you also admitted that you didn't seek consent, for which you don't have to have probable cause if you get consent, correct?
Correct.
You could ask me right now, hey, Alan, can I look at your cell phone? I say, sure, you do your thing, right?
I could.
But for
So the reason Jackson can get into this and use it basically for his case is because Lally went in with Tully. Well, what are the ways you can get a search warrant? And what can you do? And what do you have to do this? Probable cause, get it signed by a judge, blah, 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 blah. So Jackson's like, okay, let's talk about it then. Let's talk about just how easy it is. And I think he beautifully lays out how there was a pretty good argument for probable cause. And we talked about this when the first officer was on the stand. I was like, yeah, maybe there is enough of probable cause, no guarantee, but at least enough to ask. And you could have asked him. Jackson does an even better job of providing what probably is enough for probable cause. More than I thought it was originally. Now that more evidence has come out and we know more, and we know of more of what was reported, that it was maybe a domestic incident. Maybe people initially thought he got beat up inside the house. Proctor's friends were even asking questions like that. Something doesn't smell right. So let's listen to him kind of lay out what he thinks would have been probable cause for a search warrant in the house, but at the very least, you could have asked him to search it.
court to order that I hand over myself. I'm going to get a search warrant, sign an affidavit, and get a court to agree with it, correct?
Yes.
You've applied for myriad search warrants in your career, I'm guessing.
Yes.
Very experienced, correct?
Supposedly.
And I expect that there have been circumstances, Lieutenant Tully, in which you sought a search warrant and the judge says, no, I don't think there's enough here, correct?
Yes.
You don't get in trouble for that, correct?
With whom? No.
With the court.
No.
Well, it's not illegal.
It's not illegal.
You don't get sanctioned for it. You don't get your pay docked because you don't get a search warrant based on an affidavit, correct?
Correct.
So there's no real sanction in seeking it if you in good faith believe that there's a reason to seek it, correct?
Outside of the time that it takes to author it and put it together and go to court, yes, there's no sanction.
Of course. But in a homicide investigation, you're not going to fail to do certain investigative tasks because it takes time. You're going to do what is necessary for the investigation, correct?
Yes.
Of course. You indicated that you did not believe there was information sufficient that y'all had at the very initial stages of the investigation to seek a search warrant or to ask for consent, correct?
Yes.
But you did know the following. In the initial moments
Here it is.
of the beginning of the investigation, you were aware that John O'Keefe had been invited to a party inside a home, correct?
Yes.
You knew that that home was located at 34 Fairview.
Yes.
You also knew that John O'Keefe arrived at 34 Fairview, correct?
We believe so, yes.
You also knew at the time that he had been, for want of a better phrase, partying with the individuals who were inside the home, correct? Expected to meet at the house.
They were at a bar previous to that, yes.
You're aware that a drinking glass was found in the yard attendant to or close to, adjacent to where Mr. O'Keefe's body was found.
Yes.
That drinking glass had been broken, correct?
Yes.
You're aware that drinking glasses are commonly found inside homes, right?
As well as bars.
As well as bars.
So I just want to stop it when he said as well as bars. So in other cases we watch, or maybe some of you guys have been involved with cops and search warrants and being accused of crimes, maybe prosecuted, maybe arrested, or somebody you know. Wouldn't it be nice if the cops argued against searching your house? Because they're like, listen, sir, we found a guy dead in your lawn with a glass. I'm sure the glass was from the bar and I'm sure you had nothing to do with it. So I'm not even going to ask to search the house. Like, what kind of cops do that? And the cops are forcing us. Jackson didn't even like make him say that. He slid that in there himself.
Cars, right? But at that point, you didn't know. It's just broken glass, correct?
It's a broken glass, correct?
You also know that he was found without a coat on.
Yes,
Are coats normally worn outside or inside?
it's user's choice.
Fair enough. 18 degrees, you would expect if someone was outside, they'd have a coat on, correct?
I'm the kind of person that wears shorts throughout the year. I'll often go without a jacket.
All right, the true Bostonian.
Yes, sir.
I just wish he would give some other people that benefit of the doubt.
He didn't have any coat, gloves, scarf, nothing like that.
Correct.
He had no winter gear on whatsoever, correct?
Correct.
Under ordinary circumstances, and you may be the exception, but under ordinary circumstances, if someone was out in 18-degree weather, you might expect they would have some winter garb on, correct?
Objection.
Sustained.
You certainly would expect that if someone took their coat, their glove, their hat, their winter gear off, you might leave it inside the house, right? Rather than outside the house.
Objection.
I'll let you answer that, Detective Lieutenant.
It's probably predicated on where you take it off.
Right.
And your relationship to the location.
Right. Reasonable assumption might be the winter gear might be inside the house.
Objection.
Is that a reasonable assumption, Detective Lieutenant?
No, Your Honor.
Yes, it is.
It's not reasonable that he would have his jacket inside the house? You wouldn't just assume that?
Well, you're using the term the house. You talking about any house? 34 Fairview?
Correct.
No, it's not reasonable.
All right. You didn't think it was reasonable at the time
Still don't.
to even ask?
It couldn't be. No evidence could be in the house. Come on. You know better, Mr. Jackson. It couldn't be. That's what I don't like. A better answer would have been, sure, it could have been. Yeah. Yeah. But we didn't have any reason to believe anything happened in there, so we didn't search. But sure, his jacket could have been in the house. I mean, fighting these little things is what, and again, every juror is going to be different. But for me, that's what makes me side-eye. It's these little things that they fight that I'm like, why are you worried about this? I mean, I think we know by now why they're worried about it. But initially speaking, like I would give the cop the benefit of the doubt if he was just like, yeah, sure, Mr. Jackson, that's possible. I like that answer better. Yeah, that's possible. Yeah, anything's possible.
Could he have had a jacket off inside the house? And I'm talking about at the time, the initial stages of the investigation.
Who am I asking this question to?
So I'm asking if you believe it was reasonable, if a man is found 30 feet outside the front door of a home and he's got no winter gear on whatsoever, that perhaps he came from inside the home, not having donned his winter gear.
Objection.
Can you answer that, Detective Lieutenant?
It's not reasonable given other information I had.
You also know that he didn't have a shoe on, correct?
Yes.
Where might you look for the shoe if you didn't find it out by his body initially?
Well, the question's not accurate to the facts we had at the time.
Well, the facts you had at the initial stages, I'm talking about just after 6:37, 7:30 in the morning when the investigation was beginning. During those times, you didn't have any information about where the other shoe was, except he just didn't have a shoe on at the hospital, correct?
We didn't know there was a shoe not accounted for until after noontime.
So when you did find out that there was a shoe unaccounted for, one place to look might be outside, correct?
Yes.
And another place to look might be inside the home, correct?
We looked at the former and we located it there.
You also are aware that a body is being dragged by the shoulders could easily lose a shoe.
Objection.
Sustained.
Have you ever experienced a homicide in which a body is dragged and you're aware of a shoe being pulled off while the body's being dragged?
Objection.
I'll allow that.
I don't have experience with that.
Certainly not outside the realm of possibility as a professional investigator.
It's possible.
There you go. Of course it's possible.
You're also aware that, at least initially,
It doesn't mean it happened in this case, but of course it's possible.
it appeared from accounts that John O'Keefe may have been involved in a physical altercation, correct?
Possible.
As a matter of fact, that was reported by one of your subordinates, Yuri Buchanan, to the medical examiner's office, right?
As a possibility, yes.
As a possibility. And you're aware that your other subordinate, Trooper Proctor, according to certain information he had gotten from first responders, also believed that a physical altercation was possible, right? As well.
It was possible, yes.
Okay. And you also knew that the house would be a normal location to have other individuals who might have been involved in that physical altercation.
Objection.
Can you answer that, Detective Lieutenant?
An altercation could take place anywhere.
Exactly.
And people can often travel from the location of the altercation miles away to another location.
Or they could travel 30 feet outside as well, correct?
Yes.
Okay.
And again, he got better with the yes. Just give it to him. He's just giving you possibilities.
In the early morning hours of, well, let's say the hours following your Massachusetts State Police initiation or engagement in this investigation, you became aware of Brian Higgins, correct?
Yes.
That name was bantied about as a potential witness in the investigation, correct?
Yes.
And you're aware that Brian Higgins indicated that he saw a tall, dark-haired man enter the home after he arrived, correct?
I'm not aware of that.
And the reason you're not aware of it, Lieutenant Tully, is because nobody bothered to interview Brian Higgins on February 10th, right?
Objection.
So
It's a problem. It's like, well, if you would have known that somebody matching John O'Keefe's description walked into the house that night, that may have given you enough for probable cause for a search warrant, right? That would have changed your mind about having no evidence John O'Keefe walked into the house. But you didn't get that because you didn't ask Brian Higgins, because you didn't do the investigation properly. Din says, Peter, none of this was an issue until the defense attorney started a smear campaign. They knew who did it from the beginning. She admitted it, and then she backtracked. Din, this is going to offend some people, okay? And I understand people don't like criminal defense attorneys. A criminal defense attorney knowing who did something or how something happened or being told that, right? Because they weren't there, so how can they really know? Doesn't matter. The burden is not what a criminal defense attorney knows. The burden is on the state, the prosecutor, the Commonwealth, the federal government, the U.S. Attorney's Office to prove who did it beyond a reasonable doubt. And if you say she said she did it, she admitted it with the I hit him, then that should be easy. If that's what it means, the jury should convict her. If that's a credible admission and confession and the jury finds it to be that, they should convict her and none of this stuff should matter. But if the police investigation and conflicts and shadiness and talking about it the way they shouldn't and forcing the issue on one person that they clearly hated from the jump, if that puts reasonable doubt in the jury's mind, our justice system works in a way that that person should be not guilty if they have reasonable doubt, regardless of what happened before. That's why the burden's on the Commonwealth. That's why they go first and last. That's why they have all the resources. That's why most people think if somebody gets arrested and they get charged and they get brought to trial, they're probably guilty. That's what most people think walking in to jury duty. Chiricity said, do you think him answering every question with their narrative is going to prove the defense theory of bias? So this is, again, is the inverse of kind of that last question is, if the defense does a good enough job of presenting what they think the theory of the case is, that instead of the witnesses hearing, okay, good, this is the prosecution narrative, this is the prosecution, this is the state's case, this is what they want to prove, instead they start hearing, oh, obviously conflict, obviously bias, obviously prejudice with the same testimony, it's not good for the Commonwealth.
in that form that is sustained, ask it differently, Mr.
When was
President.
Brian Higgins first interviewed?
February 7th?
7th, 10th? Yeah, in February, not January 29th, certainly.
Correct.
Although he was known to be inside the house.
Yes.
So had you known that, had you had the information, for instance, that Brian Higgins admitted to having seen a tall, dark-haired man walk in the house, that might change the complexion of your investigation at that time.
Objection.
Can you answer that, Detective Lieutenant?
In the off chance that Mr. Higgins presumably had said something like that, I would certainly need more information describing this person. I would ask a series of questions to narrow it down to make sure that this person was John O'Keefe.
Right, exactly. That would just be a normal part of the investigation. You just take evidence A and link it to evidence B to evidence C. That would be the normal way to do an investigation.
We would normally follow the evidence. Correct.
But in point of fact, nobody did seek a warrant to go inside the house, correct?
Correct.
Nobody did seek to have a forensic team go inside the house and look,
Correct.
and nobody asked for consent.
Correct.
I want to ask you about
That's not good police work. It's just not. And guess what, Lauren? You're right. You're 100% right. Just look at the Chad Daybell case. Pryor was trying to point the finger at all these people doing stuff, trying to get Chad Daybell, pointed at Lori Val, Alex Cox, other criminals, trying to smear other people. And it didn't work because the evidence was good enough. And if they would have gone into the house that night, they would have been able to cross all this off. That's the point of good police work. Mo said, do you think the defense didn't ask any questions with the expert because the jury looked confused like I was and let it ride? I've got some thoughts on that we'll talk about later. Yobi, my wife said I have to be more serious, that I'm ruining your professionalism. Anyway, we enjoy watching you every day. And thank you for covering the case. I wish you were uglier. It's all good. Thank you for covering. I look forward to the lightheartedness of your comments, Yobi. No apology necessary. That's funny. That's funny. There's another one I wanted to read. So I don't know the answer to this one, Brian. If you need a CDL to drive a city plow, I'm a Florida boy through and through. We don't have plows here. So I don't know that answer. Does the defense call back some of the witnesses, McCabe, Colin, Albert, Higgins? I don't think so. I think they got what they needed out of them. And I heard they're only going to take a couple days with their case. Mo, I would like to know why they didn't show her going back to Meadows Ave from Fairview. Wouldn't that have helped with the time frame of death? It's like so many camera clips are missing. I don't know why. I don't know who deleted them, if anybody deleted them, if they're all motion censored and they just didn't pick it up. I don't know. I don't know the answer. Yobi, you did start this trend. Patrick's like, where's my check? It hasn't arrived, about paying people in the chat. Francis like, wait, we're not getting paid? A bunch of people said that. Funny. Crime to solve it. What are your thoughts on the governor of Massachusetts commenting on Proctor today? I think there needs to be more than just comments. Just my opinion. All right. Ashley asked, thoughts on evidence and report being different? That is going to be the next section of testimony we listen to.
Correct?
Correct.
2 was the date that you memorialized the information about the search, correct?
Yes.
Obviously, that was much, much closer in time than today, correct?
Yes.
Or yesterday, correct?
Correct.
If you turn to paragraph 3, could you review that paragraph and tell me, after you review it, if that refreshes your recollection about exactly what you indicated was found by you and the CERT team on January 29th, 2022?
My recollection of what was located remains the same.
I'm not laughing. My buddy who's watching just texted me, I too wish you were uglier. So thanks again, Yobi, for starting trends that are great for me. Thank you.
I do see that the report states that it was a piece of clear plastic.
Okay. So, in fact, your report says that at approximately 17:45 hours, which is what time?
5:45 p.m.
The CERT team located, quote, a piece of red plastic, correct?
Yes.
And then it goes on to say it was consistent with brake light material from a motor vehicle, right?
Yes.
And if you look down a couple of other sentences, you talk about the shoe that was then recovered, correct?
Yes.
Then if you look at the second to the last sentence, a few feet south from the sneaker, a piece of clear plastic consistent with clear lens of a motor vehicle was located, correct?
Yeah, the quote is a second piece of red plastic. Yes.
Well, actually, the sentence before that, sentence just above that, starting with a few feet south.
He thinks he's got him, but he's just not reading it right.
Yes.
It reads, a few feet south from the sneaker, a piece of clear plastic.
That's not what it says. Would you like me to read it?
Yes, it does.
Oh, I'm reading it. Sure, read it.
Okay. The sentence is,
It comes down to who is more prepared. And the best lawyers, regardless of how tough they can be and how quick they can be and how quick-witted they can be, if you're more prepared, that gives you more confidence. I am never more confident at trial than when I know walking in there, I know this case better than everybody. And for most of my cases, it's good because these defense lawyers try way more cases than we do. In insurance defense cases, they just try a case every couple weeks. And so they don't get to really dig in. They do kind of the same canned defense, you know, especially these truck accidents or car accident cases with surgeries. They just do the same stuff. It's like, you don't know this case. You don't know. It's very different than what your last case was. And so Jackson knows this case. He knows what the report says more than the officer who drafted it. And he's about to step in it here.
several feet south of the clear plastic.
Look at it all.
Sorry.
Sentence above that. Before
You're
that.
looking at the wrong
A few
sentence,
feet south.
sir.
The clear plastic.
Look at it all.
Sorry.
Sentence above that. Before that.
A few feet south of the sneaker, a piece of clear plastic consistent with clear lens of a motor vehicle was located.
Right. So in your lexicon, a piece means singular, does it not?
Yes,
If you meant pieces, you would have written pieces. You're educated, correct?
allegedly.
So clearly, from this report that was memorialized on February 10th, you indicated that a piece of clear plastic was located consistent with clear lens from a motor vehicle, right?
That's what it says.
Okay. Then, well, it's not just what it says, it's what you wrote.
Correct.
Right. Then the next sentence, which is the sentence you were about to read, go ahead and read that for me as well.
Several feet south of the clear plastic, a second piece of red plastic was located.
Okay. Simple math. According to your report on February 10th, a piece of red plastic was found first. Then a piece of clear plastic was found. Then a piece of red plastic was found thereafter, correct? According to that report.
Yes.
Then you go on in the following paragraph to reiterate, just to clear up any doubt about what was found. And the last sentence reads, the sneaker and 3 pieces of plastic were secured as evidence, correct?
Objection.
See, overruled, I don't know. What's the objection?
Form.
No, I'll allow it.
Is that what it says?
Yes.
Okay. Then yesterday, you were asked to open these 2 evidence.
You guys are killing me with some of these comments. Like, it's a serious case. I can't be cracking laughs and smiles. But Chandler, that's a good one. Matthew, yes, they can call Lucky. They can call Lucky just as a fact witness, not just to impeach, but they can call him to impeach as well.
The evidence bags.
Could I take a look?
Oh, of course, yes. May I approach you?
Yes.
Sorry. Those are the bags that you opened yesterday, correct?
Yes.
You indicated yesterday in front of the jury, you didn't indicate, you pulled out 2 pieces of clear plastic, did you not?
I did.
Okay. That was in bag, I want to say that was in bag 570. Why don't we do this? Can you please open, with the court's permission, can you please open bag 570, I'm sorry, evidence, exhibit 570 in that bag, and just look inside.
I didn't bring gloves with me, Your Honor.
I think there might be some on the stand
Oh,
there
thank you,
inside
Your
that.
With 570.
Okay.
Inside that bag.
So 570, the description is pieces of red hard plastic taillight cover contained inside this bag.
Look down in there and tell me, do you see red plastics?
Yes.
Okay. Yesterday, you pulled out 2 pieces and indicated that was what was contained in the bag, correct?
Correct.
Take another closer look.
As I take a closer look, there are 2 pieces and there is a very small fragment that remains in the bag.
Can you pull that fragment out of the bag? You sure that's what it is? Okay, you can go ahead and replace that. So in total, Lieutenant Tully, how many pieces of red plastic are in that evidence bag?
As we sit here today, there are 3.
Thank you. I'm going to close that. Open up the second bag. I'll go ahead with the first one. Exhibit
2 pieces of clear plastic.
5. You need to replace those.
So 3 became 5. Okay. And this is the perfect comment here. I love when the perfect comment comes through at the right time. Of course, I lost the perfect comment. Here it is. Caitlin, I usually believe police as the daughter of a sheriff. This trial has made me question, how often do they pick a suspect before following the evidence? Oof. I don't want to answer that question because I think my opinion would be a higher percentage than what most people would think. But a lot of times they're right with the first person they pick, right? Just because they zone in on somebody or zero in on somebody doesn't mean they're wrong. But here's what I'll say. I feel like I scrutinize police officers appropriately. I believe them when they're credible, but when they're not credible, I think I may hammer them more than most people. And this is a perfect example of that. So in his report, he talks about 3 pieces. In the evidence bag, there's 5. How does that happen? Well, if this was the only discrepancy, maybe it wouldn't be that big of a deal. But when you add in all the different people searching, all the different people putting these pieces of taillight together, the taillight being such a big part of it, Proctor going there, weeks and weeks, finding pieces and pieces and pieces of taillight, somebody from a different police department saying a piece missing, not that it was destroyed and a bunch of pieces were missing. That's what makes this a bigger deal than it might otherwise be. Because there's also people that are going to look at this like, oh, big deal, 3-5, the small fragment. Maybe he didn't take or consider that, or maybe it broke off after they put it in the evidence bag. Okay, fine. But when there's this much smoke, usually people are going to think there's fire.
Those 2 bags are supposed to represent what was found by the CERT team on January 29th, 2022, correct?
Yes.
There's 5 pieces of plastic, 3 red, 2 clear, correct?
As we sit here today, yes.
My question, Lieutenant Tully, is where did the other pieces of plastic come from?
Be more specific? Which pieces?
Where did the extra 2 pieces of plastic come from in those evidence bags?
Great question.
Well, it appears to me that small fragment I pulled out may have potentially come from the larger piece. The other,
Just to clear that up, you believe, as you sit here, that smaller piece was broken off from one of the larger pieces?
again, I'm making a big assumption here at your request.
Okay.
So yeah, that's what it appears to me by looking in the bag.
And by the way, Lieutenant,
He thinks it's possible these pieces broke apart in the evidence bag because that's not good for him either. right? That's not good. None of this is really great for them. Lane, I don't think that's their goal, but it's obviously not how you want to come across on Cross.
This isn't a trick question. I'm not asking you to assume anything. You were there and you recovered the pieces and you described recovering 3 items of evidence, correct?
No.
Didn't you just read in your report? I'll read it again. Last sentence, the sneaker and 3 pieces of plastic were secured as evidence.
That's 4. That's 4.
Sorry, I said items of evidence, items of plastic. Let's leave the sneaker out of our discussion for the time being.
Okay.
You were the one that conducted the search, correct?
The search team conducted the search. I was
You
present.
analyzed the search.
Yes.
You were there photographing the things that were covered in the search,
Yes.
and ultimately you were responsible for bagging those items up, correct?
Yes.
There are 5 items in that bag, or in those 2 bags, right? Just the plastic.
Correct.
And yet your report very clearly says there were 3 items of plastic evidence recovered at the scene, correct?
Yes.
So my question, once again, is where did the extra 2 items come from? A piece of plastic.
Well, as memorialized on the bag, it says pieces of clear plastic. So I will take the hit that my report does not properly memorialize it. But I would argue
He's like, and again, this is a supervisor. I can tell how this guy rose up the ranks. He's like, listen, I'll take the hit. I must have screwed it up in my report because he realizes he's got to pick. He's got 2 bad choices. Either more evidence showed up somehow or he wrote it down wrong in his report. And he's like, I'll take the hit. I must have screwed up the report. Which again, when we talk about just give the best bad answer you can if all the answers are bad, he did it there. Is the jury going to buy it? I don't know, but that's the best bad answer.
that the handwritten notes on the bag that are contemporaneous to the collection of the evidence would be more accurate, as is in my memory of 2 clear plastic things being collected. Now, as to the 3rd piece, again, I'm making an assumption, but it appears that that is a small piece that was separated from the other 2 pieces.
You don't know that that small piece separated from the other 2 by being broken off, do you?
No, I don't.
Just a guess, on your part, right?
It's a guess. The bags were, out of our custody at the crime lab for a period of time. They had done an analysis. We did an evidence review with you, yourself, and the defense counsel on December 1st of last year. We pulled all the evidence out. It was memorialized by your investigator, and it was put back in the bags.
You didn't see our investigator snapping pieces off the plastic, right?
He did not.
I hope not. I hope not. All right. I'm going to jump here because somebody said, and I've been waiting to put this one up. Reese's mom said Jackson negates that. And Reese's mom was talking about them driving or her driving to Fairview. So he shows the difference in miles, how far these locations are to where that doesn't really make sense. And if you look at where the cell phone tower is, the cell phone is actually a lot closer to Jen McCabe's house than it is Fairview. So it's not likely that she would have driven to Fairview at that time around 5:20 to 5:37. But it's actually likelier that she stayed closer to Jen McCabe's house, if I'm remembering correctly what JM stands for. And there's actually other cell phone towers that are closer to Fairview that she likely would have pinged off of if she was driving to Fairview. I hope I didn't screw that up because I wrote that down as the summary. Mag said, Peter, currently an undergrad at UF. I'm sorry to hear that. Just kidding. Seriously considering law school. Curious as to where you studied. Is ranking really that important? Thanks for everything. I went to Florida State for undergrad and law school, aka Harvard of the South. Class ranking in law school is incredibly important. GPA and LSAT is most important to get into law school. Mandy, hi Peter, my first SS. I have followed you since Johnny Depp and you're the best on LawTube. Thank you. I believe the prosecution is watching your recaps. By the way, I do not subscribe to LawTube. I never asked to be in it. I don't want to be in it, not associated with it. I am my own thing. I only can be responsible for what I say. That is my disclaimer always, ever since anybody's ever been talking about LawTube. But I get what you mean. Lawyers on YouTube. There's a lot of great ones, by the way. I believe the prosecution's watching your recaps. Yesterday with Proctor, today with Tully. I highly doubt it. I've been wrong before, Mandy, but I highly doubt it. I think you mean that as a compliment, so I do appreciate that. Reese's mom, Peter, are you getting hit with all the rain and flooding? My dad's like, hey, it's going to be a lot of rain. Dads are always saying something. It's going to be a lot of rain this week. I was like, okay, I'm all ready for it. I was thinking about shutting my sprinklers down. It's like, we've barely gotten any, but all around Florida, it's been crazy. We just left Sarasota this weekend and it's like flooded. Epiphany. I lean towards she's innocent, realizing it's possible she accidentally did. Sadly, we will never know what truly happened because of their shoddy police work. SC said, Peter, we will accept a new merch drop as payment. Well, you might be in luck, SC, because I've heard rumblings from John in the background that may be coming. Yobi said, what is this song along? I think you mean sing along with Yobi. These are my jokes. These are his jokes, okay? Ben, sorry if I missed it, but why doesn't AJ ask Tully and Yuri about Proctor's text, why they approved of it, how that shows clear bias? So he did ask Tully, and Tully said he reprimanded him, admonished him, basically gave him a talking to. I think basically they hit it so many times on Proctor. Maybe they didn't want to water it down, asking other people, or have somebody else maybe with more couth explain what's going on. They just wanted to see the way Proctor kind of hung his head and tried to explain it. Okay, next. Okay, so the last part of Cross, okay, I thought was the worst part of Cross. They went back and forth with a bunch of cell phone stuff and how it couldn't have moved where they said it moved. He didn't find this or that. I thought it was kind of confusing. I didn't think it was great for the defense. Not that it, did anything bad for them. Then at the end, when he talks about, I wish I would have put the timestamp on this. I could probably guess about maybe here. No, this is when she started the procedure, whether she was at this spot or that spot versus where she ended the procedure. Okay, here we go. This is it. The eyewitness testimony about the Ford Edge and why he didn't find it credible. This was really interesting to me.
Your investigation that eyewitnesses or an eyewitness placed a Ford Edge in front of 34 Fairview in the early morning hours of January 29, 2022, correct?
I'm familiar with that.
As a supervising investigator, by the way, you're familiar with the fact that the eyewitness placed that Ford Edge see if I can start that over. The eyewitness indicated that the Ford Edge was placed there sometime between 2:30 in the morning and 3:30 in the morning, correct?
I'm familiar with that.
All right. As the supervising investigator, did you do anything to investigate the circumstances of that Ford Edge being placed in front of 34 Fairview sometime between 2:30 and 3:30 in the morning?
Yes.
What did you do?
Well, we determined the veracity of that statement, and we want to make sure that the person who gave it is consistent and accurate and had a good vantage point of it. I have concerns about.
By the way, were you satisfied with that?
No.
Why not?
Well,
So what I want to do here is let's compare this to what he did with all the other eyewitness testimony from Nagel and her brother and the Alberts and the McCabe's and Higgins, people who were admittedly drinking. Some of them admitted being drunk. Some of whom were young. Some of whom weren't really paying attention. Some of whom just kind of glanced out the window, but they took exactly what they said and they knew who did it based on all of those eyewitness testimonies without getting cell phones, without corroborating anything. Before they looked at any cameras, they knew. But when it comes to this Ford Edge and the eyewitness here, then they become real cops. And I don't blame them for what they did with the Ford Edge eyewitness, right? I don't blame them. Let's cross-check, cross-reference, see if this person's legit, see if they're credible, see if their story is consistent. Because if it's not, I don't think we should consider it either. And that's exactly what the defense has been trying to prove with Allie McCabe and Colin Albert and, where the cars went on the Life 360. And what's their answer? Life 360 is inaccurate sometimes. But that's what the defense is trying to do, is kind of recreate the wheel and cross-check and do exactly what Tully says they did to this eyewitness. So let's listen to what they did here and how they scrutinized it, which I think is appropriate police work.
person has given the statement multiple times, and it appears to have changed over those times. It also appears that the person observed this vehicle from a distance. And also the identification of a Ford Edge seemed highly suggestive the way that I had read the account of it. If I had done that as a police officer, this court would throw out that identification.
So did you find out anybody in the Albert family on the Ford Edge?
I don't recall off the top of my head. If somebody,
Did you look at automobile registration records?
I did not know.
Did you task anybody else to look at automobile registration records?
I believe Trooper Proctor and Sergeant Mechanic had investigated that.
And do you have any idea what that investigation revealed?
I don't.
Did the Alberts on the Ford Edge?
I don't know as I sit here.
They did on the Ford Edge, didn't they?
Objection.
So the objection sustained.
Especially it's annoying when it's so easy to find that out, right? Like it's so easy to find out if any of them owned a Ford Edge and even admitted that it was parked there that night. And by the way, that doesn't prove that the Alberts did it inside the house. This is another one of those things where I'm like, why are you fighting this so much? Why are you fighting the Ford Edge so much?
But nothing was done further that you're aware of to investigate the circumstances of that Ford Edge being seen and placed in front of 34 Fairview, right where the body was found, between 2:30 and 3:30 in the morning, right?
An investigation into the reliability of that witness was conducted.
So you just decided, and that investigation, quotes, is, I didn't believe him, right?
No.
Yes.
All right, so that is the end of cross. And now we're going to listen to a good chunk of redirect here to see how he can try to rehab some of the issues that came up on cross.
So as far as that last line of questioning, as far as the witness in the Ford Edge, you mentioned that there were several different stories, correct?
Yes.
Several different versions of the statement.
Yes.
And what were those different versions?
The first was that this person saw a Ford Edge in front of 34 Fairview. The next one that I can recall is that the person stated that they were not on Fairview, but on Cedar Crest, some distance away, looking at this vehicle in a blizzard. Person also.
Everybody that saw everything saw it in a blizzard that morning, right? Isn't that what Lally's been telling us the whole time? But I do think it's a good idea and a good job by Lally to get up and explain why he wasn't credible.
Self-reported that he was colorblind, and he was operating a larger motor vehicle. The third story was a concern about the time. The third story was as he arrived, the Canton police had the street blocked off at about 4 a.m. and he places this Ford Edge outside the residence at a time before that. So we know through our investigation that the Canton police didn't arrive till shortly after 6 a.m. So the witnesses' times are off as well.
As far as the what you termed as the highly suggestive ID with the Ford Edge, can you explain what you mean by that?
As I read the report, the investigator had asked the person first a question. They stated that there was a vehicle in front of 34 Fairview Road. The witness was then brought outside, and the investigator allegedly pointed to a motor vehicle that was in a parking lot, and it said, "Is that it?" And the witness said, "Yes, that's it." And so it's suggestive in the fact that it would be a single photo identification, which, you know, as a police officer, I would not give somebody one thing and be suggestive, is this it? Because as the courts have ruled, that's highly suggestive, and the person's more likely to adopt that description of whatever they're describing, opposed to use other methods.
I think he's trying to hate on the defense's police work, but they're not cops, right? They're here to provide reasonable doubt, not prove a case beyond a reasonable doubt.
Now, when you were being asked on cross-examination about certain distances from the house at 34 Fairview to the area where you had recovered items, repeatedly you had been asked about a distance of 30 feet, correct?
I did.
From the items that were recovered and the area.
Oh, here's an aha moment for Lally, right? Everybody said 30 feet, but 30 feet is wrong, isn't it?
Area that was described to you as where Mr. O'Keefe's body was located shortly after 6 a.m. Is that 30 feet from the house?
No, where the items were a little further on the edge of the property, so it'd be closer to 40 or 50 feet.
Wow, could go from 30 to 40 feet in estimation, or even up to 50. Now 50 you could say is almost double 30, sure. But it's like at that point, if you're looking out the window or looking as you're driving by a car, is there really a big difference between 30 and 40 feet? I just think it's interesting the stuff that they try to nitpick at versus the big stuff that the defense has hit at.
And as far as where Mr. O'Keefe was located with reference to the curb or with reference to the street, how close was that?
From the curb, reports was about 10 feet from the curb.
And so the evidence was a lot closer to the roadway, a lot closer to the curb than it was to the house, correct?
Objection.
Sustained as to
As far as what, if anything, did you find significant between the location of the evidence in relation to and Mr. O'Keefe in relation to the roadway versus in relation to the house?
The piece of evidence were physically on the roadway, on the pavement, or the curb.
Just one question as it applies to the Sally Port video from the Canton Police Department. Are you aware of sort of how those videos were recorded as far as when they stopped, when they started?
So if anybody's wondering, can Lally ask a question appropriately? The answer is yes, because that was the appropriate way to ask this question. And he wants this cop, like he's wanted all the cops, to say it's motion censored, which explains some skips, some people appearing, some breaks in time, why we don't have certain times, because there was no motion, not that motion, real motion, like people walking. That's what he wants the cops to say. And he just asked the open-ended question to where if a cop knew, he would be able to answer. And let's listen to Tully's answer.
Not off the top of my head, no. But
No, I don't know how and when and why things are recorded in those videos. By the way, Lally has already gotten this in from multiple other witnesses that it's motion censored. But it's as if he thinks he just does not do the keep it simple stuff. By the way, it is raining here now, so maybe I spoke too soon with the flooding. But he's going to ask every witness to confirm the same fact. And he's not going to take no for an answer. And this is, again, where I just lost my patience with him. Because when you don't get the answer you want, it is improper, I'll say. I'm not going to go further than that. It's improper to then knowingly ask a leading question to put the answer in your question, knowing it's going to draw an objection that's going to get sustained, then ask the open-ended question again when he has already said he doesn't know the answer, just to get him to repeat what you said in your improper question. And that's exactly what Lally does here, and he's done it throughout the trial. And Jackson, frankly, should have objected outside the scope of this guy's knowledge. He told us, no, he doesn't know. Somebody said, I liked this comment. Where is it? Maybe I already put it up, where somebody said that, maybe Jackson was coming down a little bit off the adrenaline rush of crossing Proctor over the last couple of days. And I do think that's possible. But so let's hear Lally basically give him the answer in a question. It gets objected, sustained, and then he ends up answering it. This guy's a professional. He picked up on what Lally was trying to do.
the ones we have in possession, no.
As far as, and then I'm sorry, let me ask the question probably a little more succinctly, but with reference to, are you familiar at all with the camera system at the Canton Police Station?
Vaguely, yes.
So that's
As far as, do you know whether or not it's motion active?
The Canton IT director stated that it was motion.
So the objection is sustained.
So let me ask you, are you aware that the cameras are motion active?
Objection.
As to form its system.
Are you aware they're motion activated? That's the answer. Objection sustained. Oh, my bad. Let me ask it how I asked it the first time again.
What, if anything, are you aware as to how the cameras?
Objection.
I'm going to allow
Your approach.
it. Okay.
She allows it. Maybe that's what he said at sidebar, by the way. He did object. So maybe that's what he said at sidebar. I'll give the benefit of the doubt.
Lieutenant, when it came to the Sally Court video, at some point you did review them to some extent.
Yes.
And over the course of your review, what, if anything, did you note in reference to time? Was it sort of one long consistent, or did it jump?
It jumped.
And based on that, what, if any, conclusions did you draw as to how that video recorded?
It appeared to be motion activated as these jumps occurred. It appeared to be triggered by motion.
Now, with reference to
Literally the biggest eye roll in the world. And again, I don't know that jurors pick up on this. So I'm not going to say, a juror for sure picked up on this and knew that was BS. But like for me watching, those are the types of things that just annoy the crap out of me to see lawyers do.
items that were recovered on January 29th during the 13th search that you were present for. In addition to your police report, how, if at all, were they memorialized?
On the exterior of the paper bags that they were contained in.
And when was that done? Before or after February 10th, when your report was written?
Objection.
Ask it differently, Mr. Mueller.
When was the memorialization on the evidence bags done in relation to when you wrote the report?
Objection.
I'll allow it.
The difference would be the notes on the outside of the bag happened at the time of collection, and then I wrote my report 11 days later.
So is Lally supposed to make us think like, well, it couldn't possibly be still accurate in his mind 11 days later? No way. And for sure, he didn't make any notes while he was collecting this evidence in a homicide case. Like, that doesn't make it any better. And I don't blame the witness for that, because the witness is just answering the questions. But it's like, the witness already handled that. He's like, I must have screwed up my report, period. But to act like, well, because his report was 11 days later, then don't wait 11 days to do your report. How about that? Can we do that? Can we have quicker turnarounds on reports on homicide cases if you're going to screw it up 11 days later? Like, that's not a good excuse. Charlie, did the judge allow the defense their ER doctor as a witness regarding the dog bites and scratches? I haven't heard. I'm going to guess yes at this point, but I think we're going to see the voir dire at some point. EP, We haven't even, oh yeah, she hasn't made the decision because they haven't done the voir dire yet. We're gonna see that. We haven't even heard the Commonwealth call a medical examiner. I'm hoping that's what's left. The only thing we've heard about a medical examiner came from the defense cross, and it was that they couldn't convince her to put homicide, right? Which means she put undetermined. By the way, we're going to find out when the Commonwealth is supposed to finish their case in chief. We're going to listen to like a 1-minute video from Alan Jackson, which, you know, Twitter can be a good place too. Somebody tagged me in this video. Beetle. Does being a juror once in a different case make a person more qualified than a new juror in a case? Not necessarily more qualified. Some lawyers like people that have been jurors in other cases. Some lawyers don't. So it all depends. If you didn't get a verdict in that case, because usually we'll ask, that can be a negative. But then again, you kind of may know the ropes a little bit more or what to expect, but one case can be so different from the next, especially if it's civil versus criminal or federal versus state. So it really depends. Every trial is so different.
So, as far as your memory, as you sit here and testify today and yesterday, as far as the items that you took out of the bag, are those the same items that you recovered or were recovered by the search team on January 29th?
Yes.
Now, the information from the call detail records that Mr. Jackson presented to you, there was essentially 2 little columns, correct?
2 rows, yes.
And was that sort of the entirety of what you reviewed as far as the call detail records in relation to generating the slides that were given to the jury?
No.
And I'm sorry, Mayor Pro Tem?
Yes.
May I see the exhibit? Given you earlier?
Don't really appear on here. If they do, they're light and faint.
So this is what the defense made and used for him. And Lally's like, haha, we're going to hammer this. Tell me what's wrong with this. And listen to how horrible this defense demonstrative aid is. I don't know if it's an exhibit or a demonstrative aid, but this is how he hits it. And again, I don't think this was planned. I don't think Tully was ready for this, but he did his best.
Depicted on there, what, if any, issues do you have with the depiction on that exhibit?
Like I mentioned, it's difficult to get a good sense of what we're looking at because the roads don't really appear on here. If they do, they're light and faint. There are the large black line kind of intersects with a lot of them, with the words of them. At the bottom, it looks like it's written map scale next to a scale, but I can't attest to the veracity of that. Those would be a couple problems I see.
Now, with reference to the slides that you created with the different time frames, not just the one single time frame. Again, the times that you observed or the location of the handset, of the cell phone of the defendants that you observed from the call detail records, were they consistent with other pieces of evidence that you had, whether it be video and or written statements?
Yes.
And that would be consistent with the location of the defendant, correct?
Yes.
Now, we're asked some questions about speed and distance traveled. And you indicated that you did not agree with the premise of Mr. Jackson's question, correct?
Yes.
Can you explain to the jury what it was about the premise or what it was that you did not agree?
So while I agree it would be impossible for the phone to travel at that distance, I disagree with the premise that the procedure that was being captured here and the distances may not be at the same time. So there may be a distance could have preceded the procedure and the end distance could have been after the procedure. There are other ways to capture that information. Again, all I'm doing, and I'm at the mercy of the records, is illustrating them. I then take the next step in order to corroborate that information, ideally through video and other location-based information.
Now, in relation,
So he's trying to say how much of a better job he did than Jackson, basically. Tiny E, to me, this comes down to the first set of taillight pieces. Did the cops have time to plant them at the scene? They were under the snow, right? That's going to be a question for the jury, right? That's going to be a question for the jury. Sandra, let's say Karen is acquitted and sues. Could we get more info on the alleged cover-up and what's in the Fed's file through a civil suit? Potentially, I think they may have a lot of that, though. My cat's name is Karen. Hasn't this triggered a federal investigation? It sure has. It sure has. War Critic, do you know about the towing man getting threatened? I do not. He was told by one of the cops, if you ever mention this again, I will fire you. Now, was the witness threatened? Seems he said they actually investigated this witness. So I have no idea about that. And if that witness is called, maybe we will hear some about that. Where's a good local place to buy men's shirts? Need one for a gift, but found out today RBK, maybe Roback, no longer makes the requested shirt, now shooting in the dark. I either get my golf shirts from like actual courses that I go play at, because I have so many, so I pretty much only want to get them from, you know, cool new courses I go to or my home course, or online. I pretty much just shop online. And I have so many golf shirts from around the world that you guys have sent me, which is so crazy and cool. Why do attorneys have to ask permission to approach the witness? Great question. Number one, it's just for candor of the courtroom. The judge is in charge of the courtroom. We don't want witnesses to get nervous, or attorneys to charge witnesses, for safety. So the bailiff knows where people are walking about the courtroom, so they're not charging the jury. It's just respect and candor and kind of a profession of ethics and professionalism. Never, never. How did Jackson miss when Proctor said in text message that she hit him in the driveway and he died? Jackson, Proctor said in text message she hit him in the driveway and he died. Are you saying because it's the driveway? I'm not sure specifically what you're referencing from the Proctor testimony. Kerry Roberts was the first detective on scene. That's good. That's funny. Okay, let's jump now to, actually, there's a little bit more of this I want to listen to. Then we're going to jump to talk DNA.
To speed, is that something that you've done in other cases with fault detail records?
Yes.
And you mentioned that you weren't able to do it here or didn't do it here. Can you explain why not?
By speed, do you mean route of travel or?
Yes.
So if I have a more robust set of records, so again, we're at the mercy of Verizon here. We only got a limited number of records from the ranging data. With other cases, if the phone is much more chatty with the antenna, if there's more lines of communication, I've seen lines of communication as frequent as every couple of seconds or less than a couple of seconds. As I map those out, I can make more of a determination of maybe the route of travel of the cell phone. So as I put the first arc, I'll then place the second arc on a map and say to myself, how could a handset get from the first arc to the second arc? And I'll have a number of possibilities. I will then lay out the third arc. Okay, how could a phone get from the second arc to the third arc, and repeat that process, narrowing down the different possibilities. And oftentimes I'm able to determine the route of travel, send investigators down to that route, and we find corroborating information.
And again, why was it that you weren't able to do that with this information that you received from Verizon in this case?
We received a limited number of entries in this record.
And what, if any?
So it's Verizon's fault, right? It's Verizon's fault. Okay, so then we get to a couple DNA experts, which will show them here. Collecting DNA, testing the DNA. More people tested the DNA after lunch. Let me just give you my thoughts on this, okay? And you guys can give me yours in the chat as well. I got to find mine. Here we go. All right, so they took the DNA from Proctor and Urey. I don't remember them saying that they tested all of this against Proctor and Urey. They definitely said they tested it against John O'Keefe. And basically, they got that the taillight DNA matched John O'Keefe. The glass, the cocktail glass matched John O'Keefe. The stains and the blood and stuff on his clothes matched John O'Keefe. The hair, one person said they couldn't test it. Then when they did the mitochondrial DNA, sounded like the hair did match John O'Keefe. Okay? So all the DNA, all the testing basically matched John O'Keefe. And this is where kind of I mentioned off the top, the way a jury looks at a case and the way a jury feels that they are kind of leaning as the case goes or which side they're on is going to dictate how they view this evidence. Reasonable jurors could absolutely differ in huge ways on this evidence because the state wants you to believe the only way the DNA from John O'Keefe gets on the taillight, the cocktail glass, the only way his hair gets on the back of her car and his blood ends up on his clothes is if Karen Reed, in fact, hits him. And if there was no DNA from John O'Keefe on any of those items, they should lose. But there is. Therefore, they should win. And I think it is reasonable for a juror to find that way. But what's the other way to look at this? The defense has made very clear their arguments. That number one, there's no way a hair this big stayed on the back of her car through all the snow and all the wind and the driving and the towing and the parking and all of that. There's no way. So it must have been planted, right? Because that's what they say. That's what they're arguing. But how'd the DNA get on the taillight? Well, They had the cups of blood. They had the taillight. When they smashed the taillight, they must have just, rubbed it around the blood. They had John O'Keefe's DNA all over the place. It wouldn't have been hard for them to transfer it onto those taillight pieces when they broke it, shattered it, and planted it, right? That's your theory. And that may be why they have to have this theory. And that's why they're pushing this theory. And it's not just reasonable doubt. Because if a juror is with you as the defense, you give them these points to argue with the other jurors when they're back there deliberating and arguing. So that'll line up. That'll answer the tough questions that they have. But what about some of the other stuff we heard? Like unidentified persons. 1, 2, 3. Unidentified persons' DNA was also there. The defense is going to say, oh, must have been the Alberts, must have been the McCabe's, must have been the real person who did this. Somebody could believe that. Not me. Somebody could. I think it's a red herring. I think the state would argue, and I think they'd be right to say, could have been anybody. Somebody hugs him. Somebody takes a sip off his glass. There's video footage of people hugging each other, passing glasses around. The bartender passes glasses around. Bunch of different ways. The touch DNA that he explained. So what did this actually prove? And I think it could be really important if there are jurors that are really with the Commonwealth. They see it. I saw some people on Twitter like, ha, do all you people who thought reasonable doubt feel stupid now? There's no other way DNA could have possibly gotten on his taillight. I'm like, could think of some other ways. Did they make sure the DNA ended up on his taillight like they wanted to make sure the medical examiner gave a homicide determination? I don't know. But to me, that's not the end all be all in this case. There's so much reasonable doubt everywhere else. Number one being, how did the car cause these injuries? Which is why I think they absolutely have to call some medical experts and an accident reconstructionist. That has to be there for the Commonwealth in this case. Well, when are we going to hear from them? I think that's a valid question. And this is an interview of Jackson after court today. And he lets us know when the Commonwealth is planning on ending their case in chief. Now, they still can have a rebuttal case, and the defense, I think, said they're going to take 4 days, and we know it's going to end before, July 1st or before the end of June. But when will that be? When will this come? Let's take a listen to what he said. And also, he's going to tell you what he thinks about that hair. And again, the defense hasn't been shy with what their theory is and how all this DNA ended up everywhere.
Made it.
Hold on, it's a little low. So I'm going to boost the audio. So everybody just get ready for boosted audio here. Why don't you all take a second and hit the like button? See if we can get this video to 15,000 likes. And if you haven't subscribed already, please subscribe. I'm going to answer some more questions after this interview, but let's listen to what he says in this interview. It's a great watch, by the way, and a great suit.
On a 70-mile journey in high winds and sleet and snow and wind and blizzard conditions, it's ridiculous. Say that again. Oh, if they're saying it was on the back of that car, it was planted. I mean, there's just no way for it to assess it any other way. Somebody placed it there.
Well, there is a way to assess it another way. It is possible, I guess, right? It's physically possible. Maybe they're going to call an expert that says it's not physically possible for that to happen. But what's he doing? He's pushing his theory. He's pushing his agenda of the case. And that's exactly where they want the jurors' minds to go. And I think that's where a lot of people's mind in the chat went. Automatically, when you hear it, you're like, yeah, well, duh. Of course the DNA is going to be on the taillight. They planted it. That means the defense is being persuasive in how they're trying this case. Because it's not the only way to look at the evidence. There are multiple ways to look at a lot of this evidence. And the jury's going to have to figure out, did the state prove beyond reasonable doubt, or are a lot of the defense's arguments more plausible and more possible? Because if they are, which I find a lot of them more plausible and possible, that's reasonable doubt. That's absolutely reasonable doubt. Cover up or not, somebody else did it or not, reasonable doubt has to equal not guilty. All right, so let's hear when the Commonwealth's case is going to end.
or somebody pulled it off and put it in an envelope and then had it tested. It is of no consequence. It certainly doesn't suggest that John was hit by a SUV.
Quickly,
Thanks, guys.
any update on when this prosecution will rest?
Tuesday.
Tuesday
I
they'll be
think so.
done?
That's what they're suggesting. Yeah.
Okay.
Yeah, that's what they're saying. Thanks, guys.
Representative Attorney Alan Jackson.
Tuesday. Special teams, special plays. So they think that it's going to be over on Tuesday for the Commonwealth. That leaves Friday, Monday, Tuesday. 3 days left, and they finished early today, so they're almost done. Are we going to get medical expert testimony? Are we going to get the accident reconstructionist? Those are the two most important witnesses that I've been waiting to hear from the Commonwealth. And maybe saving them to last is good. The last thing the jury remembers before they hear the defense's case. They didn't hide him in the middle. Tom said the defense not cross-examining any of the DNA evidence spoke volumes. I mean, it didn't hurt them. Their theory of the case is we knew it was going to be there because it was planted. So if it doesn't hurt you, why dig into it? Why provide clarity? Because a lot of times the defense has provided clarity on what the prosecutors were trying to do on direct. So don't provide clarity if you don't need to, right? Hannah, could the defense say in closing, the state tried to mislead you by treating the cops like medical experts, or would that get objected to? Saying the state tried to mislead you, I mean, they probably could say something like that, but what they should say is they knew the medicine didn't line up. That's why they tried to get it through the cops. Now, theoretically, commenting on objections, certain judges wouldn't allow that. I would say it because they tried to get, and the cops did actually testify to some medical stuff. He just did. And what's consistent with this and consistent with abrasions? She let him testify to that. So I'm going to say they're not medical experts. What medical training do they have? Would you want them diagnosing you? Of course, you can't say that. But Leah, in Massachusetts, you have 90 days to determine cause of death and manner in regards to an autopsy, mortician, and lifelong mortician family here. Emmy is going to be so interesting, Peter, if they call her. And Proctor called her a whack job, which she's probably not going to like. But she made sure anyway it was undetermined. That is telling. Yeah, she wasn't in the bag, that's for sure. Dana said, Peter, I bet your DNA and hair are on your wife's car, especially my hair. But it wouldn't be a hair this long, right? It would be a lot longer of a hair. My hair seems to be literally everywhere. Noel, DNA. John O'Keefe would have been around her car. It was parked at his house. It's not that far-fetched to say it came from the fact that they were dating. Well, that's not what the defense is saying. They're saying there's no way it could have stayed on her car after all that driving, all that snow, all that towing. It is kind of crazy to think all these hours later, she drove back, parked it in the garage, left, towed, drove around to other people's house. Curicity. They said no blood or tissue on the taillight. Cops touch taillights all the time. Oh, wait, taillights on stops all the time. In case something happens, their prints are on it. So not surprised, John touches her taillights. Sure. Never. Proctor in his text messages to the group of friends, it was brought up that Karen hit John in the driveway. This is a conflict of facts so far. Conflicts in the evidence can be reasonable doubt. Brianna, I can tell you how that truck could have caused those injuries. So could any national general insurance adjuster who works in transportation and private passenger vehicles. Okay. Gringa, I handle a lot of car accident cases too. I've never seen injuries quite like that, unless, again, they were dragged or slid across the pavement or asphalt. Gringa, if you were Lally, how would you feel about the strength of your case? Horrible. Could Lally offer a new plea if not confident in conviction? Sure, I would. I would offer a plea deal. I would beg them to take anything. And if they took anything, you could say, aha, we were right. It was smear campaigns. She knows she did it. We just couldn't prove it was intentional. It was an angle we couldn't prove. Azam, stay safe, Peter. Take care. See you, Azam. And thank you for gifting a membership on the way out. That's all we've got for tonight, folks. I appreciate you guys joining us, hanging out, asking your questions, hanging with us. Realize we don't have all the answers. We don't know for a fact exactly how this is all going to pan out. But none of his DNA was found under her car, so that wasn't the case. Yeah, I agree. That's what I'm saying. Like, What does it really prove? Everything was touching everything. People were touching this and that. When he walked by her car, he could have just put his hand on her tail light. I don't know. Yeah, people are asking, why would you take a plea deal? I think a plea deal would be a huge win for the Commonwealth. A huge win. All right, that's all I got, folks. Woo, some thunder. The storms are coming. Storms are coming. All right, everybody stay safe out there. Hit the like button on your way out. We'll see you tomorrow night. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.